This is the third of 3 videos that BBP University Law School students have produced about what to expect at a final Employment Tribunal hearing. This video covers what happens at a hearing after all evidence has been given.
The information in this video is for general guidance only. We recommend you seek legal advice in relation to your personal circumstances.
If you do not get through all the evidence within the allocated time for the hearing, then you will be asked about your availability and a further date will be fixed for everyone to come back to the tribunal to finish the hearing. Once all the evidence has been given, each party will present a summary of its case. Sometimes the judge will also ask for written submissions in advance. You should explain how the evidence presented during the hearing demonstrates that the judge should rule in your favor. Keep your points relevant and be sure to cover every issue. In a simple case, the judge will give judgment as soon as they have heard the summaries. At other times, the judge will call a recess and the parties will return to their respective waiting rooms until the judge is ready to give judgment. In a complex case, the judge will reserve the decision and send a written judgment to the parties at a later date. In giving judgment, the judge will summarize the findings of fact and how they applied the law to those facts.
If the judge has decided in the claimant's favor, they may decide what remedy to grant there and then. Other times, they will list a remedy hearing for a later date. For an upcoming remedy hearing, the claimant should update their schedule of loss to cover all losses accruing to the date of the hearing. At the hearing, the claimant will give evidence as to the loss suffered and will be cross-examined. The respondent will also give evidence and will be cross-examined. Once again, the judge may ask questions at any point. The judge will then give their decision on remedy. If you think the judgment was wrong, you might decide to appeal. You can only appeal on a point of law, meaning you have to believe one of the following things is true. The judge either got the law wrong, did not apply the correct law, did not follow the correct procedures, and this affected the decision, had no evidence to support its decision, was unfairly biased towards the other party. You cannot appeal on the findings of fact made by the judge.
You will receive guidance on how to go about appealing with the copy of the written judgment you receive from the tribunal. If you do decide to appeal, you are advised to seek legal advice if you have not done so up to that point.
There's a strict time limit of 42 days to appeal from either the date the decision was sent to you or when the written reasons were sent to you, but only if the tribunal didn't provide reasons at the hearing or you asked for the reasons within 14 days of the decision being sent to you. Your appeal must arrive at the EAT by 4 p.m. on the final day. Late appeals can be considered, but you need a very good reason, and even then, extensions are very rarely granted. Now that you've learnt about what happens when you arrive at the tribunal, what happens during a hearing and at the end of a hearing, we hope you're feeling much more relaxed about your upcoming hearing. Good luck and watch our 3 videos as a refresher when you need to.
Created using Powtoon.